In 2011, the government commissioned report on a review of the family justice system was published. David Norgrove headed the committee which produced the report. In 2012, the government has now responded to the recommendations and made clear that there are going to be sweeping changes to family law. This video is to give you a quick run-through of some of those changes. An important law in this jurisdiction is the Children Act 1989, which covers matters such as contact and residence for children, as well as care and adoption proceedings. And it is that law which is going to be fundamentally changed in some areas, according to the government's proposals. One major change that we are going to see is that there is going to be a presumption of shared parenting. Currently, if a parent can't agree with the other parent about the caring arrangements for the children, where the child will live, contact arrangements, etc., either can apply to the court for a judge to decide the arrangements. We don't yet know what a presumption of shared parenting in the Children Act 1989 is going to mean to our clients and their cases, but I can imagine that it's going to be quite a change if you don't agree the amount of contact the other parent has with the child and you make an application to the court, or they do. You're really on the back foot if you're arguing it's less than shared, when the court are going to have this presumption in law to follow that it should be shared. I've just mentioned contact and residence orders. That's another change recommended by the government, that they are to be abolished. Contact is the arrangements for the parents seeing the children. Residence covers where the child is to live. They are going to be swept away, and there's going to be a new child arrangements order in place. That presumably is going to cover contact and residence, and the reason why the change has been recommended is because it is seen to have winners and losers if one parent gets residence and the other only contact. One thing I'm disappointed about in the government response is that although mediation and dispute resolution is mentioned and recommended, there is no mention of collaborative law, although that was in the Norgrove report. As you may know, I'm a big advocate of collaborative law, and I would heartily recommend it to separating couples. If you would like further information about it, please have a look at the great deal of information on our website. Although not my area of law, there are also considerable changes to be made to adoption and care proceedings for children. Judges are to be given a more robust role in deciding and ensuring the timetable for the child is to be met and the procedure is to be speeded up. Some commentators are concerned that perhaps this may mean that not all of the information is explored and fully investigated before a decision is made, which has far-reaching consequences for a child. Finally, there is a change in divorce law in that the form couples have to complete when they are to be petitioner, called a Statement of Arrangements for Children, is to be abolished. That's a whistle-stop tour of some of the changes envisaged in the Family Justice Review for us all to grapple with. I'm Lisa Pepper, a partner at Osbornes in the Family Law Department, and I'm also a mediator and collaborative lawyer. If you would like to discuss with us your case or have some advice, please have a look at our website for our contact details and lots more information about family law.